Vladimir, hello.
Hello.
My name is Nikita Shalov. I am a lawyer at the Sadekov Law Office. Today, sworn advocate Vladimir Sadekov and I will talk about criminal law.
With pleasure, with pleasure.
Let's talk, Vladimir, about criminal proceedings.
This is my favorite subject.
That's wonderful. I hope we'll have an interesting dialogue.
Without a doubt, yes.
How exactly can a person understand that criminal proceedings are about to begin?
We can choose two paths. The first path is easy. The second path is difficult. Let's choose the middle one. This means that a case is initiated based on cause and grounds. A cause is any information. It could be a newspaper article. It could be a neighbor's complaint. It could be anything at all. Grounds are the elements of a crime, its objective part. For example, they found a body in the forest with signs of violent death. There are grounds for initiating a criminal case. For example, they found a document with signs of forgery. There are grounds to initiate a criminal case. At this stage, the subjective part, like intent or negligence, is not considered. The presence of signs is what matters most, and based on these, a criminal case is opened.
So, okay, formally a criminal case was initiated, but how does a person find out that they are a subject of this process?
Well, for example, as the first procedural action, they'll take him and detain him for up to 48 hours. They'll arrive, put on handcuffs, escort him to the police station, to the detention center, and that's how he finds out that a criminal case has been initiated against him. Or they'll call him and say, "We're inviting you to give testimony as a suspect. Get yourself a defense lawyer, or we'll provide you with a public defender."
And does it often happen that a person is invited, for example, by the investigative authorities as a witness, and then he actually becomes a suspect in this process?
In my practice, it's happened several times when a person was questioned as a witness, and by the next questioning, he was reclassified as a suspect. As a witness, he must give testimony. He cannot withhold anything. The only thing is that he can choose not to give testimony against himself, but few people know about that. Everyone usually tells everything they want, and then, yes, by the next questioning, he already turns out to be a suspect and is already forced to give testimony or refuse to give testimony as a suspect.
What potential risks does this entire process actually involve?
The biggest risk, undoubtedly, is related to the fact that a person can lose their freedom, at least for some period. Well, let's say he was detained for 48 hours. His deal fell through, his negotiations didn't happen, he didn't take his child to practice anything at all. This is the first thing, this kind of physical impact. It's terribly demoralizing, it complicates a person's life incredibly. Besides, he can go into custody, that is, they can take him into custody. If we're talking about a second-degree crime, then they can hold him in custody during the pre-trial investigation for up to 4 months in total. They grant a warrant for 2 months, then they extend the warrant for another 2 months.
But in the case of the first degree?
Up to 6 months. Accordingly, yes.
However, it is also worth noting that if the individual involved is a minor, then the duration is up to a total of 2 months.
Naturally, of course, there are details here. Absolutely. But the most critical and significant aspect to consider is how it disrupts and interferes with every part of a person's life. Naturally, it's abundantly clear that all those actions he took while he was free, they're all utterly and completely ruined beyond repair, yes. In other words, it's such an intense measure of significant impact that it can ruin a person's business, it can ruin their entire personal life, it can ruin their business contacts, business ties, and everything else they have. So,
and if we're talking, for example, about a person's property?
Well, they can simply seize his property. If, say, it's a property crime or a crime that entails some kind of property damage to the state or to some victims, then the suspect's property can be seized. And not even just the suspect's property, but also the property of a third party. Say if he acquired something, stole it, or obtained it through some fraudulent actions or underpaid taxes, or did something else and registered it to a third party, let's say, yes, hid this property, then the third party's property can also be seized, frozen, and ultimately confiscated.
But let's move on then to the actual court proceedings. Suppose the prosecutor is already handing over the criminal case materials to the court.
So the pretrial investigation has ended. One way or another, the case was handed over. The case materials were handed over to the defense for review. The defense has the right to submit its motions within 10 days, or maybe a little later, a little longer if it's a complex case. Suppose the defense didn't make any motions. The case is sent to court, and the accused receives, that is, the suspect receives the indictment and enters the status and transitions to the status of the accused. So upon receiving the indictment, he becomes the accused. Next, the defense lawyer reviews and briefs his client on this indictment. And accordingly, if the case proceeds in general proceedings, a preliminary hearing is scheduled. For the preliminary hearing, the defense must prepare a defense statement. In this statement, the defense statement, he must reflect all his motions. He must reflect the viewpoint, the line of defense specifically in the defense statement, and submit it to the court at least 3 working days before the preliminary hearing. If he doesn't do this, or if he misses it, if he overlooks something, it will be very late later, practically impossible to catch up in the general process. These are the specifics of the general process.
But surely another path can be chosen.
Well, it's known. Do you know, Nikita, what other types of legal proceedings there are besides the general process?
First of all, it's worth noting that the criminal process can be concluded even before the case is sent to court. However, if it really has been sent to the court, then this issue can be resolved through simplified legal proceedings.
Let's go back to that. For example, you could say the case could end before it's sent to court. What do you mean?
We're talking about the principle of so-called expediency.
You mean opportunity?
It's also called opportunity. Exactly right. There are two grounds for applying opportunity. First of all, it should be noted that, of course, this decision is made by the prosecutor. And if, for example,
if public attention isn't that important, if it's not that socially significant, then the case can be terminated by opportunity. What else could there be, in your opinion?
Yes, indeed, if the public interest is not high, then the prosecutor can terminate the criminal proceedings. Or, for example, if there is no expediency in punishing the person.
Yes, indeed. But back in the day, ages ago, there was a measure where a person was released on bail. Back then, a long, long time ago in the early 90s, you could release someone on bail and terminate the criminal case through that. But now that's been abolished and the principle of opportunity was introduced, which has several grounds. Actually, the most interesting fact that I want to tell you, once back when large organized criminal gangs were involved, cases were occasionally closed, not even based on opportunity, but based on helping the official investigation, which was a truly significant contribution to solving the crime. On that basis, the criminal case was also terminated, but the person had to perform some actions in favor of the police. Naturally, there were those too. There were cases like that too. Let's go back. Let's go back to the types of legal proceedings. What do you think, from your point of view, which type of legal proceedings would you personally prefer?
I would also mention, returning to opportunity, I'll quickly mention that when it comes to opportunity, it is nevertheless very important for the person to somehow compensate for the damage. They don't just terminate the proceedings for no reason.
That's an opportunity.
Of course.
Exactly.
The conditions can be completely different. For example, in case there is no public interest, then indeed the prosecutor terminates it and can impose some obligations on the person. But if there is no expediency in punishment, then the consent of the victim themselves is also required. Yes. So returning to your question about the legal proceedings themselves. In order for a person to minimize risks and somehow make the process more understandable for themselves and foresee its consequences, one can choose, for example, settlement proceedings.
Yes, settlement proceedings.
Exactly.
Yes.
Tell me, please, how often is settlement proceedings actually chosen after all? Or do people prefer to go through the standard legal process?
Well, I would say that probably roughly 60% of my practice. People prefer settlement proceedings specifically because they want to avoid taking risks, solely in order not to take risks, because they know for sure, yes, what punishment is being discussed, and they choose this type of legal proceedings.
But at the beginning of these proceedings, first and foremost, negotiations take place between the defense counsel and the prosecutor.
Yes, it's a lengthy process and not always a peaceful experience. It's an emotional kind of event and not a one-time thing. It can take a long time. It's not that easy to find common ground with the prosecutor. And based on the materials that were collected, quite often you have to add some materials that were not discovered during the pre-trial investigation in order to motivate and ask the prosecutor's office to meet you halfway. Well, that's the essence of settlement proceedings, to determine the type and amount of punishment. Once the specific type and the extent of the punishment are determined, the parties come together and sign an agreement. The agreement is sent to the court. The court may reject it and return it to the prosecutors. This has happened more than once. You settle with the prosecutor and file it. The judge rejects it. Insufficient punishment.
But what if, for example, a person does not admit their guilt, but at the same time is truly afraid and does not want to take the risk of going through a full trial?
That's the most interesting part. Actually, according to the law, a guilty plea is not required to choose a settlement procedure. But some judges will still ask. Some judges will ask, do you admit your guilt? And one might say, well, yes, partially. For instance, he might admit guilt just to reach this agreement. Some judges, exhausted by the end of the working day, might ask, in what part exactly, and so on. Of course, you prepare every single client to answer correctly, ensuring this settlement procedure actually takes place as it should.
And yet it's not a requirement. And
I believe it is not.
an agreement can be reached even in the case of...
This is not my favorite type of legal proceeding, just like the summary proceeding as well. Do you know what a summary proceeding is?
Yes, it is a fairly straightforward process where the legal proceedings are conducted based on the documentation and evidence that have been formally submitted to the court.
That's exactly right. Let's say the claim, it must be submitted to the prosecutor's office and then reach the court along with the materials, and other documents and pieces of evidence are submitted during the pretrial investigation. So essentially, in a summary proceeding, you cannot submit almost anything to the court anymore to supplement the case, to add any additional evidence to the case. So if we're talking about the defense, it's extremely important to do everything in your power, specifically during the pretrial investigation. If you choose this particular summary path, this isn't my favorite type of legal proceeding.
Are there any objective indicators that could potentially speak in favor of a summary proceeding?
Well, for example, I would like to ask you, do you know how it affects the punishment?
If a person chooses a summary proceeding, then the punishment will be reduced by 1/3.
Yes.
Especially when compared to a full trial.
A great number of people fall for that. Many people contemplate the idea, but it is only truly compelling when there is no doubt about the defendant's guilt. Then it makes sense to choose this summary path. If there is even the slightest doubt, if there is any dispute, then of course it is better to choose a full trial where the defendant has the right to defend himself effectively, where the defendant can present his arguments, evidence, and so on, and the like. So a summary proceeding was also good because in the event of a guilty verdict, whatever that guilty decision might be, yes, the judge, let's say, might disagree with what the prosecutor requested and give a significantly lighter sentence in a summary proceeding. The prosecutor didn't have the right to file an appeal. That's why it was also very beneficial because, for example, the prosecutor requested actual jail time, but the court gave a suspended sentence and the prosecutor didn't have the right to appeal that. That's also a very interesting decision. So, of course, we could talk for a considerable amount of time about these criminal proceedings, but our format is somewhat constrained. So let's thank everyone for paying close attention to our conversation, and we hope that we'll discuss some more significant and relevant topics with you and things that might be of great interest to our audience watching at home.
Thank you, Vladimir. Thank you for listening to us.
Thank you.
Thank you.